Yeah, dear students, good afternoon. So in the last class, we discussed about, can you see my slides? I'm changing my slides. Let me know like whether it is applicable. Last class, we discussed about patent related activities like patent analytics, where we discussed about different kind of searches, freedom to operate, novelty search, and patent landscape analysis, patentability search, and patent prosecution, patent litigation, and licenses or acquisition, everything we discussed. And I also discussed about what is the process for what is the patenting process in India and the corresponding timelines. Today I'm going to discuss about in detail what are the timelines and what are the basic concepts which are required any invention the patent to be granted. So this is the basic sample examination report. After you file the patent, so after 18 months, automatically it will be published. And within 48 months from the date of priority date, you can request for the examination. So after examination has been requested, so patent office will start examining your patent application. So normally, patent office within 6 months, it will issue the first examination report. So this is the sample examination report. The patentability, as you know, the patentability criteria. So novelty, inventive step, and industrial application. Apart from that, non-patentable subject matter. Your invention should not fall into the non-patentable subject matter, which we have discussed already. So with respect to that, if any objections are there in the patent office, these objections will be described like this. This is the first examination report issued by the patent office. After you request for the examination within 48 months from the date of priority date, this request for the examination that will be resulted, and first examination report will be issued by the patent office. So these are the sample examination report. If you can see requirements under the Act, the first one talks about section 21J, which describes about the invention and what is inventive step. If any issues with respect to the inventive step or with respect to the novelty will be, any objections are there with respect to that will be mentioned here. So and corresponding claims also, if you can see claims 1 to 9 here, if any objections are there, the claim number will be mentioned here, and it will be mentioned that if any objections are there. So similarly, this is the non-patentable subject matter. So what are the objections with respect to non-patentable subject matter, and corresponding claims will be given. So non-patentable subject matter as per the Indian Patent Act, which is under section 3. So 3D, 3F, and 3P. These are the objections raised by the patent office. And if you can see, these are the specifications. The third row talks about objections with respect to the specification. So you can see what are the claims which does not have the does not satisfy the specification with respect to the enablement, best mode, and sufficiency of disclosure. All these three criteria we will be discussing. So I will take one invention and how it will be assessed, what kind of objections the patent office can issue, and what exactly the patent office examiner will assess, how it will be assessed, all those things through one example I'm going to discuss here. Before that, I'm gonna cover some basic topics. So types of patent applications, we already discussed provisional and complete specification. So within 12 months from the date of filing provisional specification, you have to file the complete specification. This is with respect to the India. And also there are another concept which is called convention application. So the convention application is the members who are part of the convention, Paris Convention. So if you want to protect your invention in the corresponding respective country, for example, there are almost 180 countries, more than 180 countries are part of the Paris Convention. So you can protect your invention apart from in India. If you feel that if you want to protect invention in other countries as well, you can file through Paris Convention. Imagine if you file a provisional specification in India, within 12 months you have to file a convention, Paris Convention application in a convention country. So because patent is a territorial, that's the reason whatever the right you get it belongs to it is given by the respective country. So if you want to get your invention to be protected in different country, so you have to file in a different convention country. So similarly, there is another mechanism which is called Patent Cooperation Treaty application. This is the international application which is managed by again WIPO, World Intellectual Property Organization. Through PCT, you can file. Almost 153 countries are members of the PCT. So that you can file in 153 countries. If you file PCT, you can secure your priority date in 153 countries. It doesn't give a worldwide patent to you, but if you file a PCT, you can secure your priority date in 153 countries. So already we have convention, Paris Convention. Why we need PCT? In Paris Convention, you have to file your application in different country who are members of convention country within 12 months. If it is more than 4 or 5 countries, it is very difficult to manage simultaneously filing a patent application within 12 months in more than 4 or 5 countries. For that purpose, we have a WIPO PCT application, which is an international application. There, if you file your PCT and you can select more than 4 or 5, you can manage very easily. So that's the reason PCT application has been introduced. Ordinary application I told, which contains provisional and complete specification. Remember that provisional or complete, if you file a provisional specification in India, within 12 months, you have to file a convention application, or you have to file a PCT application, or you have to file a complete specification. So timelines are 12 months. So please remember that. Provisional and complete specification, it is within India. So date of first filing to, if you want to file in a different country through convention, that is also at 12 months. Through PCT, what is the advantage with PCT? You can get extra 18 months apart from the 12 months. So total 31 months you will be getting if it is India. So if you are filing through PCT application. So ordinary application, that means if you want to protect only in India through provisional and complete specification within 12 months from the date of filing of provisional specification. And if you want to protect in other countries as well, so data filing from the date of filing of first application within 12 months, you have to file your application in a different country through convention, through PCT. So here provisional complete specification. Provisional specification is nothing but application can be filed earliest as a provisional. That means first, India follows the first to file system. That means imagine if 2 people have come up with the invention, whoever files the first, their invention will be protected, and the second invention will be the prior art to the first invention. to establish priority date or establish early ownership. So that's the reason, though your invention is not fully ready, imagine if you have come up with 60 or 70%, and you feel that within 12 months I can come up with 100% of my invention. So to secure your priority date, you can file the provisional specification so that you can secure your priority date, and the novelty will be checked before the priority date. And complete specification, as I said earlier, if you are ready with complete invention, you can also directly file the complete specification without going into provisional specification. But it is always safe if you file a provisional specification, and if your invention is imagine if you finish 60 or 70%, the remaining 30-40%, that means 100% if your invention is completed, then you file a complete specification within 12 months from the provisional specification, which is a first filing application date. So this all comes under ordinary application. So now you have one exercise here. Imagine you have filed one provisional specification today, which is on 30th September 2023. By when you have to file complete specification, I have given the option. Can anybody will say? You have filed one provisional specification today, that is 30th September 2023. By when you have to file complete specification? You can open your chat box and you can type. Yeah, I cannot see the answers. Yeah, the answer is, as I said earlier, 12 months. You have to file a complete specification 12 months from the date of first filing, which is a provisional specification. So the answer is 12 months, 30th September 2023. Before 30th September 2024, you have to file a complete specification. Otherwise, your application will be abandoned. So I wanted to discuss another concept, which is called patent of edition. So a patent of edition can be filed for improvement or modification of the invention described in the main application, which is currently under prosecution or has been granted. Before, patent of edition is nothing but you already have come up with some invention, you already filed. So after publication or after a complete specification, you feel that there is some information should be added, which is addition to the current invention, which you wanted to protect through patent. So that information you can add by using patent of edition application. By filing a patent of edition before term of the patent, you can file the patent of edition before term of the patent. So what is the term of the patent? 20 years from the date of filing. So it can be filed before the expiry of the main patent. As I said, the patent is 20 years from the date of filing date. Till that time, you can file this patent of edition, and will expire when the main patent expires. So no renewal fees is needed. So a patent of edition can be filed for improvement or modification of the invention described in the main application, which is currently under prosecution or has been granted. Even after grant also, you can file the patent of edition, or during the prosecution of the prosecution means from date of filing to before the grant, that is called the prosecution. During that time, even after the grant of the patent, also you can file a patent of edition till 20 years from the date of filing. So another concept is divisional application. For example, if you file application, what is the concept behind divisional application is one application for one invention. Imagine you have come up with the invention and you file a patent application. and it contains 2 inventive steps. That means 2 inventions in your invention which you wanted to protect. So it can be filed only during the pendency of the main application. More than one divisional application can be filed. Term is same as that of parent application. So what I'm trying to say here is, if your invention contains 2 inventions, for example, you file a patent application, in that you mentioned 2 inventions. So you can divide those inventions into 2 applications. That is called a divisional application. This can be filed during the pendency of the main application. Whichever application you filed during the pendency, only you can file. That means after the grant, you are not supposed to file. It is not allowed. So more than one divisional application can be filed. Imagine your invention contains 2 or 3 inventive steps. That means 2 or more inventions are there. Then you can divide your applicant into 3 divisional applications. So term is same as that of parent application. What is the term you get for the main application or parent application? 20 years. That you will be getting for even divisional application also. You are dividing it, right? For even those applications also, you will be getting the same term. So now it is the exercise here. You file a patent application 4th June 2021 year, which is granted on 29th December 2022. So by when you can file a patent of addition and divisional application? First, I wanted to know when this patent will expire. Can anybody will say? Can anybody can open the chart and you can write the answers. When this patent will be expired? This is filed on 4th June 2021 and it is granted on 29th December 2022. So when it will be expired? This patent will be expired and will come to the public domain. And also, by when you can file a patent of addition and divisional application? I'm looking for your answers. That's good. It's the right answer. 4th June 2041. Yeah, very good. Yeah. Very good, very good. Yes, exactly. So the term of the patent is 20 years from the date of filing. So the filing date is 4th June 2021. So plus 20 years. And when you can file a patent of addition till the term of the patent, you can file a patent of addition and you can add a modification or you can add a substantial, you can add information also to the current invention, current patent application till the term of the patent. And divisional application before grant only you have to. Divisional application before grant only. So when the grant happened, 29th December 2022. So you can file a divisional application before the grant date only. After the grant, there is no point of examination and there is no point of getting another patent application to be granted, because divisional application, if you in your invention which you want to protect, which contains more than 2 inventions, then you can apply for divisional application. That too you can request, or controller will ask you your invention to apply for a divisional application if 2 inventions are there in your invention which you filed on 4th June 2021. So divisional application can be filed before 29th December 2022. So hope everybody understood this. So convention application, I said already, any country that is a member of Paris Convention, if you have filed an application in country A, you can file it in country B within 12 months. So novelty will be checked based on the first filing date. So first filing date, which is nothing but a priority date. So you guys already told answers, like within 12 months. If it is a provisional specification within the country, complete specification you have to file, that is 12 months. Or if you are ready with the complete specification and if you want to file or if you want to protect your invention, some other countries who are part of the Paris Convention, for example, US, UK, so many countries are there. So that also you have to file within 12 months. So Paris Convention country, almost entire world, all the countries are part of the Paris Convention. These green color countries are part of the Paris Convention, and whatever is not marked, they are not part of the Paris Convention. So your invention you can secure in all this country within 12 months from the first filing in India. And it is true, and it is vice versa, and it is true in other countries as well. For example, in USA, some guy come up with some invention and he filed the patent application, complete specification. So within 12 months, imagine if you want to protect in India or any other country for that matter, within 12 months, he has to file the same application. So timelines to remember. So please remember the timelines. File complete specification within 12 months. And publication of patent application 18 months from the date of priority. So here filing is first filing, which is a priority. Remember, 18 months from the date of priority. Request for examination 48 months from date of priority. Here the filing means first filing, that means priority date. So remember the priority date. And publication of grant of patent, after patent is granted, it will be published. So this is application publication. This is after the grant publication. So after the patent has been granted. Remember this timeline. This is filing complete specification. So within 12 months, you have to launch your application if you want to protect in other country. Publication of patent application 18 months from the date of priority. Request for examination 48 months from priority, date of priority, and after the grant. So again, it will be published. So please remember the timeline. So terminologies to remember. So as I said, prior art, all information that has been made available to the public in any form before a given date. And state of the art. State of the art means something like a stage of technological development at any particular time. For example, today, whatever the technology that is available in patent literature or non-patent literature. That means in the world, whatever the technology that is available, that is nothing but state of the art. Novelty, being new or original. So novelty means newness. Inventive step. Inventive step means, as I discussed earlier, non-obviousness. I told, like, person ordinary skilled in the art is the imaginary person, positor. It should not appear to him that this invention is a obvious one. So that also it will be verified by the patent office. I will discuss in detail by taking one example. So they will check novelty and inventive step and priority date. So date of first filing of a patent application is nothing but priority date. I explained in detail before. For example, provisional specification, when you are not fully ready with your data. So file a provisional specification. In this case, priority date is the provisional specification date. And within 12 months, you have to file a complete specification, which is that filing provisional and filing complete specification within 12 months. That is called ordinary application. For example, if you want to protect in different country through Paris Convention, date of filing of priority date, that means first filing, to within 12 months, you have to protect in other countries as well. Complete specification when you are ready with your data. So patent office in India, there are 4 places. These patent offices are available. Your invention, if you want to protect your invention, you have to file a patent. Nowadays, you are filing a patent through online. So these are the patent office: Kolkata, Delhi, Mumbai, Chennai. Our region comes under Chennai, Andhra Pradesh. So these are the Indian Patent Office website. These are the website links. You can go and explore. patent applications through different routes. As I said, one is ordinary application. You are directly filed at Indian Patent Office, like provisional, and within 12 months complete specification. If you want to only protect in India, and another one is convention application. I told within 12 months from the first filing in India. If you want to protect in other countries, PCT international application. So this is another way of protecting your invention in different countries, multiple countries. If it is 3 or 4 countries, 3 or 4 or more than that, it is very difficult to manage to protect your invention by filing in the respective countries within 12 months. But if you file a PCT, if it is more than 5 countries, other than filing in your own country, so it will give a 18 months extra than 12 months. And you can secure your priority date in all the countries which are part of the patent cooperation treaty. Almost 153 countries are part of patent cooperation. What is the difference between Paris Convention and PCT? If you want to protect more than 4 countries, it is very difficult to manage filing within 12 months in all the 4 countries or more than that. So in that case, PCT will be useful. So convention route, file at country A today, file at country B within 12 months from today. Your date of priority is today's date, where you filed at country A. So the novelty of your application will be checked based on your priority date. Here the priority date is, if you file today, right, that is the priority date. So before that date, in entire world, state of the art will be checked. And if that is available or not, if that is not available, then that is called novel. Inventive step I will discuss in further slides. Any application for the same invention filed by third party after your priority date will be rejected. If any application or any similar invention files before date of first filing, that means which is the priority date, so then your patent will be rejected because somebody else already invented your invention or similar invention. So Paris Convention, I told, right, it's more than it's now 180 countries more than. So PCT is nothing but Patent Cooperation Treaty. This is also managed by the World Intellectual Property Organization. And this is also called the International Application, PCT International Application. World Intellectual Property Organization is that is a top agency in the field of intellectual property, which manages all the protocol like Paris Convention or PCT. That is the administrative agency. Even World IP Day is managed by World Intellectual Property Organization, which is on April 26th. PCT provides a single window for filing in multiple countries. Almost 153 countries are members of PCT. So that does not mean one application gives worldwide. If you file a patent through PCT, it doesn't mean that all the 153 countries you are getting a patent. Patent is always a territorial right. So patent right means the corresponding government has to give a right to you. It doesn't mean that you file a PCT patent, you are getting a worldwide patent and you will get patent in all the multiple countries which are part of the PCT. What it will give is, it will protect your priority date in such a way that it will facilitate by filing a single PCT application, you can protect your priority date in all the countries. So you no need to rush that, you need to file within 12 months. So I need to file in all the 4 countries, like in convention application. These problems can be avoided by using the PCT. If you file a PCT application, you can secure priority date in all the countries which are part of the PCT. 153 countries are part of the PCT. And you get more time to choose which country you want to file. Normally 12 months for the convention. So if it is a PCT, it is a 31 months to file another PCT contracting country after filing the international application. So you have 31 months. Apart from 12 months, you have 18 months extra time you will be getting from the date of priority. So in that way, you can manage several applications. Anyway, the moment you file a PCT application, the priority will be protected in all the countries. For example, 10 countries, if you want to protect your invention in 10 countries apart from India. So filing through convention application, within 12 months. Separately, you have to file in all these 10 countries through convention route, which is very difficult. If you can go with the PCT, and if you select these 10 countries, that if you select in these 10 countries, the process will be the application, the administrative process, like something like because you filed through PCT and selected 10 countries. After 31 months, you have time. In between, you will be having enough time that whether your invention is having real capability or real potential to launch that country or not. All this information you can access. Basically, it gives enough time, more than 30 or 31 months. So, and you no need to file each and every country through PCT. So almost 154 countries are part of the PCT. I told, right, what is convention and what is PCT. So if you want to secure patent protection in only a few countries, go with the convention. If you want to protect your invention in very less time, go for convention, because 12 months only from the date of first filing, which is a priority date. Non-PCT member countries are, for example, Argentina, Pakistan, Taiwan. These are very rare countries who are not part of the PCT. PCT provides a platform where with a single application, applicant can file his or her application in a PCT member countries. They are protecting their priority date in PCT member country by filing a single application. It will facilitate by filing a single application. You no need to run each and every country and file a separate application. If you file through PCT, single application, that is more than enough. But you don't get a worldwide patent. It will facilitate by filing a single application. It will facilitate as if you filed in all these countries by filing a single application through PCT. But the prosecution and all everything, you have to get it done through respective countries by hiring a corresponding patent attorney in that country. So remember that because you are filing a PCT application, which is a single application, it doesn't mean that it will give a worldwide patent rights. It just provides the facility rather than going into each and every country and filing. You just file a single application for PCT. It is almost equal to as if you filed in all other countries. But the prosecution in those countries, you have to go through. That is called national case. Within 31 months, you have to file in the corresponding country. I mean, you have to prosecute in corresponding country. How to file a PCT application? So, can you file an international application under Patent Cooperation PCT in India? Yes, it is possible to file an international application known as PCT application in India in the patent office located at Kolkata, Delhi, Mumbai, or Chennai. All these offices act as a receiving office for international application. You can file a PCT because India also a one of the receiving office. So you can directly file a PCT application if you want to protect your invention in different countries, more than 4 or 5 generally, more number of countries, by filing a single application. Imagine if you want to protect in 2 countries only other than India, then it's always better to go the convention country. Within 12 convention route, within 12 months you have to file from the date of priority. Written permission is required from patent office if you want to file outside India. For example, you all are computer science student. So you have come up with the invention and you came to know that that invention is not patentable because that invention is falling under non-patentable subject matter, which is mentioned very clearly in section 3, saying that this patent is, this kind of inventions are not patentable. Imagine you have come up with the invention which is not patentable in India, but you come to know that that is patentable in some other country like US or something. So whether you can directly file in USA if you are an Indian resident? The answer is no, you cannot file directly. So you need to take the permission from the Indian Patent Office. And they will give, normally they will give reply within 21 days. In 21 days, they will give a reply saying that if they give yes, you can go ahead and file. then it will be allowed in some other country, for example, USA. Or there is another option that you file in India, within after 6 weeks you can file in abroad through convention or through Paris PCT. So that is another option. Why they are asking, if you are Indian resident, you need to take a permission if you don't want to file in India, because if any atomic related stuff is there or not. So in that cases, they will issue the secrecy direction. So, and they will stop that invention to file in other countries. So for that purpose, you need to take the permission if you want to directly file a patent in other countries. Content of the patent application. So normally you file a patent application, right? So these are the substantial contents of the patent application. See, for example, if you want to protect your invention, this is the title of the invention. Title, which is the title of the invention. Background of the invention. Summary of the invention. Background of the invention means what are the drawbacks of the existing state of the art, what are the drawbacks, and how you gonna solve that drawback, that you can mention in the background of the invention. And summary of the invention, so you write about what is the summary of the invention, explanation of the drawings, corresponding drawings with respect to your invention to make patent office to understand your invention, and description of the invention. You write a detailed description of the invention, like, if you are protecting a product or process or both, you write each step by step, like how to come up with this invention for process, or if it is a product, what are the parts of the invention of a specific product, and what is that you're going to protect, that in detail you are going to write in a detailed description of the invention. And claims means, claims are nothing but these are legal boundaries. It's something like, in your invention, we are writing based on your invention which you disclosed in of the invention, that we are writing in terms of legal language. So that is nothing but claims. This legal language is nothing but these are something like a it gives the scope and boundary. It's something like, it's something like a China wall for a country. So China wall protects the China from other countries to invade. In the same way, these claims are nothing but these are the legal boundaries. So that is the exact part you gonna protect. So that we are writing in a legal language, which is called a claims. So abstract is nothing but you are writing a technical details and what is it is going to solve, without going much into the details. That is called abstract. Sequence listing, if any, and INID code, which is called international agreed numbers for identification number. This is used for bibliographic data. As I said earlier, claims are, define the legal protection boundary of your invention. You will be writing the description about invention, right? Like how you need to construct this invention, if it is a process, or if it is a product, or if it is a both, what is the process to come up with the invention? You will be writing in the description, right? That description, patent attorney will be writing in a legal language, which is called the claims. So define the legal protection boundary of your invention. What exactly novel element and which contains an inventive step and industrial application. That one only you can claim. That you will be writing in the claims in the legal rank, which will be protecting your invention. Define the monopoly to be conferred by the patent. That is the monopoly you're gonna get it. At the time of infringement proceeding, only claims will be interpreted. So for example, you are disclosing something, and if that is not written in the claims, then tomorrow if some infringement happens, what is infringement? Infringement is nothing but if somebody is using your invention without your consent, that is called infringement. If you want to sue that guy because he is infringing your invention, then it will be the claims of the invention will be assessed, and patent office, I mean court will, because you have to sue in the court only. The court will interpret the claims and see whether they infringe, the person who is infringing, whether he is infringing your claims. That means without your consent, whether he is using your invention, which is mentioned in the claims. So written in a single sentence, can be independent and dependent claim. So in the claims there are two things, which is the independent and dependent claims. So independent claim is nothing but you are writing the substantial novelty and inventive step will be covered through independent claims, and dependent claims means so the remaining part apart from novelty and inventive step which are relevant to that will be dependent claim. So basically in the legal language, we are writing based on the description which you disclosed, right, in the invention. So in the legal language, the claims will be written in this format, like something like an independent claim or dependent claim. So dependent claim, which is depending on the independent claim. So product or process claims. If you want to protect a product of your invention, then product claims, or process, then process claims. If you want to protect both product, end product, out of that process, that which is called product by process, that kind of claims also you need to write in the claims. The legal language, basically you are writing, which will give a protection to that. Tomorrow, if some infringer, tomorrow if somebody uses your invention without your consent, that is called infringement. If you want to sue that infringer, then these claims are very important. So these claims are, IP attorney will write the claims based on your description, what you have written in the description. I will show IDF as well, invention disclosure form. Normally, whoever have come up with their invention, for example, you all are part of this university, we have designed the invention disclosure form. That is our own proprietary form, designed by our department. So whoever has come up with some invention, they have to fill that form, invention disclosure form. So based on that, we will be writing this description and claims, and we will be filing patent application with corresponding whatever I have discussed in this format. We will be writing that. In this format, we will be writing that, and we will file the patent application. So for that, we are providing a invention disclosure form, which is a proprietary form designed by us. It is designed by Dr. Ananja and me. So I will show what is the invention disclosure form and how we need to write, so that tomorrow, if that is that will be converted into this form while filing the patent application. So how effectively you need to write an invention disclosure form, that we will discuss in the further slides. The claims I already discussed. See, these are the claims. For example, this is a car. Car is already existing in the state of art. So the novel part, which is in the colored, claim is a statement of technical facts expressed in the legal terms defining the scope of the invention sought to be protected. So whatever is not claimed remains unclaimed. For example, though you disclosed in the description of the invention while filing the patent, in the description it is there, but in the claim it is not claimed, then it remains unclaimed. For example, here you will see simple claim drafting example. Claim on a car with a roof made of vinyl. Vinyl is nothing but this one. This is the top, which is in a different color. Actually, this is the one you are protecting, not the car. Car is already there, wheels are already there. So some novel element which is satisfying inventive step and industrial application. So then in that case, you are protecting actually this colored one. So how you gonna write claims? I am actually describing here. A car with a roof made of vinyl. Claim to it, the car of claim 1, where said roof is black. You are explaining that, you know, this said roof is black. Actually, this is a black color. On top of the car one, it is shaded with different color, right? That is a black one. So here claim 1 is the independent claim and claim 2 is the dependent claim. In the claim 1, Actually, you are discussing what is the novel element. What is that you're going to protect? You are protecting some venial. So with that, what are some advantages and disadvantages? That is the independent claim. So you are describing about the car of claim 1, where the said roof is black. You are describing about is the black or what kind of material you are using. The car of claim 1 further comprising a rain guard attached to said roof. So you are describing about that roof, that venial. So now you understand, right? What is the independent claim? Claim 2 and claim 3 are dependent claims. Claim 1 is the independent claim. So the novel element which satisfies the inventive step in industrial application and what exactly you want to protect, that is called independent claim. So which here claim 1 and claim 2, claim 3 are, it's something like, you are describing about that the venial which you want to protect, which is there on the top of the car, you can see, right? Hope you understand what are the claims. So this is nothing but a legal language. You are writing if you disclose your invention and if you write in detail in the description, by seeing the description, IP attorney will convert. You have to hire a IP attorney. So IP attorney will convert it to the claims and in this format. In this format, he also writes the title, background, summary, and along with that claims. Claims is the main important one. So he will write the abstract, sequence listing, and INID code. He mentioned everything, and then he will file a patent. So, for example, after filing the patent, this is the US patent. You can see the inventors here. Who are all the inventors? They are the principal investigators, like who have come up with this invention. And SN means who is the owner of the invention. For example, if you have come up with any invention, who will be the owner? The owner will be the Andhra investor, and you will be the inventor. So those things will be defined in the IP policy. We'll be discussing about IP policy as well. What is that IP policy and all. You can see international patent classification, IPC and CPC also I will be discussing. International application number. This is the PCT application. So you can secure your PCT in 153 countries I told, right? These are the countries, AO, ATA, AU means Australia, something like that. IN means India. So international filing date. This is the filing date of the international filing date. This is the one. I told earlier, international file, you can file directly international application, or you file application in India, and if you want to protect in some other countries, within 12 months, you have to file a application, which is a international filing date through PCT, or you can file a convention application as well. So within 12 months, we filed a international filing date, which is 30th March 2016. Here they filed a direct PCT application, I guess. This is filing language and publication. These are the applicants. Applicants are nothing but owner. And these are the designated states where you can directly file your PCT application. So India is a receiving office. You can, if you are an Indian citizen, you can file directly a PCT application by designating India, and normally it is in a Delhi patent office. You can directly file the PCT application. Normally, if you want to protect, if you come to know that your invention is having potential in all the countries, before filing in India, so directly you file a PCT application. And in India, you can file a direct PCT application because India is a receiving office, one of the receiving office. If you are an Indian citizen, you can file a direct WIPO application, and by designating India. Patent classification, I told right earlier here, international patent classification, this is IPC. 51 international patent classification, this is IPC. What is this classification is nothing but to easily identify. For example, this invention might be related to some computer science, in that it is relevant to some specific field, something like IoT, Internet of Things. In that IoT, it is relevant to something like artificial intelligence. In that, it is specifically relevant to the some blockchain technology. Imagine. So to mention all these things, we are using some codes. It is like a tree structure. For example, H is computer science field. H02 is something like H08 is something like Internet of Things. H02H is something like artificial intelligence. You are using it, right? So in that way, what kind of specific technology you are using, you can use the symbols. So worldwide, there are two kinds of notifications are there. One is IPC, one is CPC. A patent classification is a system for examiners of patent offices or other people to categorize the patent document according to the technical features. I just told one example. There might be so many technical features. We cannot put everything under single code. So we categorize it to something like first H, under H, some big category is there. Under H02, some small category. Under H02H, some small subcategory. Something like that we have classified. So that tomorrow, if you want to search based on the classification, also you can search very easily. So there are two kinds of classification. One is IPC, which is IPC is nothing but International Patent Classification. Normally, WIPO uses IPC classification, and USPTO and European Patent Office. USPTO means United States Patent Office. Those people use CPC, Cooperative Patent Classification. So you can see the tree structure and all by using International Patent Classification. I have given the link here, or Cooperative Patent Classification. I have given the link here. So before you file a patent application, okay, you will be giving to IP attorney, right? He will prepare the patent application. So you need to disclose the invention, which is invention that belongs to specific category. So based on the category, they will be writing the IPC or CPC. Patent office will assign IPC or CPC. So that tomorrow, if they want to search, it will be very easy to search because it has been classified. So and so invention is specific to this one. So by using this IPC or CPC codes, you can identify. These are the free patent database. I will show IP India. So how you can search what are all the patents that has been granted in India. Paid patent databases, for now it is not required because so many free patent databases are there. So Indian Patent Office I will show right now, and Google Patent also I will show, and European Patent Office Espacenet, it is down today. US Patent Office database and WIPO database. WIPO, these are all the free database. WIPO database, I told, right, World Intellectual Property Organization is the top agency with respect to intellectual property in India, in the world. So they also come up with one database. So all this database, they provide a patent literature and non-patent literature that is available in the world. So why they have come up with the paid database? Because they provide the extra features as well. That's the reason. These are the paid database. You can see Darwin and PadBase. So many artificial intelligence based databases also they have come into the market. So I already discussed about patent infringement and oppositions also. So now I will explain. Now I will explain. I will take one invention. How exactly when this imagine you have come up with one invention which is a smart inhaler. This is your invention. You are a student of Andhra University and you have come up with this invention, smart inhaler. Your invention, your smart inhaler invention incorporates advanced sensors to monitor inhaler usage, a mobile app for dose reminders, and data transmission capabilities for healthcare providers. So you have come up with the invention, and You think this kind of invention is nobody has come up this kind of invention in entire world. You think so? You already confirmed by doing some patent database search, something like Google patents, something like the way how you search Google. You have Google patents also. So and you come to know that this invention, whatever you have come up with this invention, you can file a patent and it can be protected. So imagine this is your invention. So what are the benefits of your invention? Your invention is having advanced sensors to monitor inhaler usage. How to use this invention, because that is having advanced sensor, and also a mobile app for those reminders. So you can install some app where it can give some reminders. This time you have to use this inhaler or something like that. And data transmission capabilities. You can transfer the data between the smart inhaler to mobile app and vice versa. And this kind of invention, imagine nobody has come up with, and you have come up with that invention, and you wanted to seek a protection, patent protection. So for that, what you can do is, first you have to search whether similar, to make sure that similar kind of invention that are available in the world, or because if you want to get a patent, you need to satisfy novelty, inventive step, and industrial step. What is novelty? It should be novel. It should be new. Nobody else in the world should not be able to come up with this kind of invention. It should not be available any patent literature or non-patent literature in the world. It should be basically, it should be novel. So for that, you need to search. First of all, if you search only, you can find out, is there any patent with respect to my invention, or if anybody has published some information with respect to my invention, or if anybody has using this kind of invention in the public domain. So then only you will come to know if you start searching. So if you start searching and you come to know that there are 3 patents which are already filed, which are similar to that, and but which are lacking some features. For example, that is D2. That I am calling it as prior arts. That means which is already available in the public domain, but it is not exactly like your invention. For example, D2 is a connected inhaler with sensors to track medication usage and a companion mobile app. So it contains mobile app and sensor to track. These 2 features are there, but it lacks the data transmission capability of your smart inhaler. Your invention is having data transmission capabilities. This invention doesn't have. So in that way, your invention is novel, obviously, when compared to D2, which is a prior art, which is already available in the public domain. And D3, imagine you found another invention which is similar to that, but it is lacking some other features, something like D3 is a reminder inhaler with a mobile app to set medication schedules and send dose reminders. But it doesn't have the sensor technology for usage monitor. Your invention is having sensor technology, but it doesn't have. When compared to D3, you compare your invention with D3, definitely there are 2 unique elements which other than this dose reminder, with a mobile app to set a medication schedule and send dose reminder, it does not have the sensor technology. So your invention is having sensor technology, though remaining 2 are already available in D3. So when compared to D3, so D1 is unique because extra element is available, because D3 doesn't have the sensor technology. And coming to the D4, this is the standard inhaler like normally you find in the market. So D4 is a traditional inhaler with no smart features like advanced sensor, a mobile app, and data transmission cable. So basically, if you have come up with the invention, if you search patent databases, you will find the nearest patents which are already available in the public domain, or which are filed by someone, and which are not having exactly whatever the invention you have, like 3 features. In that way, when compared to individually, you compare D2 with D1, yes, D1 is unique and D1 is novel. And D3 with D1, yes, D1 is a novel. And D4 with D1, yes, obviously, because D4 doesn't have these three elements, advanced sensor or mobile app or data transfer capability. So when compared to all the prior arts, D1 is new. So in that way, novelty requirement is satisfied. For example, now novelty requirement is satisfied. So you are very happy that novelty test has been passed because your invention is a novel one. And if what is the inventive step? Inventive step is nothing but they find out the closest prior art. That means D2, D3, D4 are the closest prior arts which are very near to your invention. So these inventions, how the inventive step is, because second criteria to pass a patentability criteria is inventive step, which is a very important one. So inventive step, what you can do is how they will assess in the patent office, or even before filing the patent, you need to check whether I am satisfying inventive step or not. You found out already near closest prior arts D2, D3, D4. You can combine the features of D2, D3, D4 and see whether you can get D1 or not. So that is the exact test that patent office will be doing. Even before the filing patent also, better you do these things. Normally, if you file a patent, before filing the patent, you will be giving to IP attorney or any law firm, right? They will do all these things. But it is always better you know that how the novelty, how the inventive step will be done. Now, inventive step, what they do, in the novelty, they are individually comparing D2 with D1 and see whether it is novel or not. D3 with D1 and see whether it is a novel or not. D4 with D1 and see whether it is novel or not. If that is novel and no other prior invention is available in the world, then your D1 application, which is a smart, your invention smart inhaler, which is a novel. How inventive step will be assessed? Inventive step will be assessed. You can combine, you means examiner here, or the person who is assessing your inventive step. You can combine prior art features D2, D3, D4. You can combine all the features and compare with D1, which is your invention. And if you combine all the invention and if it is coming D1, then that is not satisfying inventive step. That means it is obvious to person skilled in the art. So it should not satisfy. If you want to satisfy inventive step, though you combine the features, and if you are not getting this D1, and it is not obvious to a person who is skilled in the art, then your inventive step is satisfied. I repeat again, you combine all the features of the prior arts, D2, D2 plus D3 and compare with D1, or D2 plus D4 and compare with D1, or D2 plus D3 plus D4 and compare with D1. Whatever the nearest prior arts you find it out, you combine all the features and compare against your invention and see whether it is whether it looks obvious or not to the person who is skilled in the art. He is an imaginary person from your field. Smart inhaler is something like it is a medical device. So the person who is skilled in the art, Posita here, he is an imaginary person. So in the patent office, who is from pharmaceutical or medical field, he will be assessing by combining D2, D3, D4. Will I able to get D1 or not? He will see. If he is getting directly D1, then it is obvious. So your inventive step is not satisfied. If it is not, if the person who is skilled in the art, who is sitting in the patent office, who is from the relevant field, medical field or from the pharmaceutical field, and if he feels that though you combine all the prior arts, and if I am not able to get my invention, not able to get the invention, your invention, then then it is non-obvious. That means your inventive step criteria is satisfied. This is the exact what. This is the thing that happens in the patent office. Even before filing the patent, it is always better to get it done. The patentability criteria. That means they in the law firm before filing, they will search novelty, inventive step, and industrial application. Industrial application means basically it talks about utility, usage, any economic advantage is there, or any technical advancement is there or not with your invention. They will see. For example, in your invention smart inhaler, definitely some economic advantage is there. Tomorrow, if some manufacturer will come up with, you can give the license to some manufacturer by getting some royalty, and definitely it is definitely it will satisfy the industrial application criteria. So some economical advantage is there, and technical advancement also there, because in the prior art nobody has come up with this kind of invention. So if these three criteria are satisfied, then it is called patentability criteria. Then the patent office will issue the patent, provided your invention does not fall into non-patentable subject matter, which is section 3 and section 4 of the Patent Act. So now I will explain what are the databases and how you need to search before you file a patent. So it is always better to know how to search. And also I will show the invention disclosure form as well. You can hear me, right? So now I will show how to search. So IP India is our website. IP India in pass. This is the term you have to search. So you can open patent search. I'm selecting it. So you can see this is the link. This is the official website of the patent office. You can search your patent here. This is the website. This is the website. So this is the page where you can search all the patents. For example, if you want to search what are the patents that filed in Andhra University. See, Andhra University, whoever files in the patent, as I said earlier, as per the IP policy, I will show the IP policy as the Andhra University website. Academics, go to the intellectual property rights. There, resources, you can see here you IP policy, intellectual property policy, and also you can see invention disclosure form. This is the form. If you have come up with any invention, then you need to fill this form and you need to send it to us. IPR chair at the rate of andhra.edu.in. So this is the invention disclosure form we have created. It is created by Dr. Anjay Rai Chaudhary and Ashok Upputuri. That is me. So this is the proprietary form. So based on this form, IP attorney will come up with the application. So we will collect this information from you. So basically you need to know what exactly we are describing here. See, this is the invention disclosure form. So did you check whether your invention is patentable in India or not? Basically, if you open this link, it will redirect to these are the non-patentable subject matter, section 3. So your invention should not fall under this category. For example, you are a computer science student, right? So you can see section 3K of the Act, a mathematical or business method or a computer program per se means by itself or algorithms by itself, it is not patentable. But if you can come up with any program which will be solving some technical problems, which already existing technical problem is there, that if you can solve, though it is a program, and if you can bring any memory efficiency, or if you can bring any executive time efficiency, though it is a program, still it is a patentable. You are a computer science student, right? That's what I'm saying. There is a case called Provisional versus Union of India. So in that case, it is very clearly told that though it is a program, if you can show some technical advancement by solving any technical problem which already exists, and if you can show some memory efficiency or execution time, if you can reduce, so still it is patentable. So though it falls under non-patentable subject matter, if you can show that that is solving some technical problem, long pending problem, which will result in some technical advancement, like if you can bring some technical effect by solving that problem, or if you can bring some memory efficiency or executive efficiency, then definitely it is patentable. So before going, you need to check whether your invention is falling on this or not. If it is not falling, happy, you can select this one. Did check whether your invention is patentable in India or not. If you check it, put yes. Checking means basically you go into this website and you are checking. Your invention is not falling, then you can fill this one. If it is falling, so you cannot file the patent. You have to come up with some other changes where it cannot directly fall into the non-patentable subject matter, which is mentioned here. Doesn't mean that you have to stop your invention. You have to come up with some technical advancement in your field if it falls directly in such a way that you can file a patent. So these are the general information. This is the title of the invention. For example, in our case, I explained one inhaler, right? Smart inhaler. So you can write something like title of what is the title of the invention? What is the technical field? It is relevant to medical field or pharmaceutical or something like that. Details of inventor. For example, if you have come up with the invention, so you write your inventor name. Okay, you can write there is no limitation. It's 4 or 5 inventors or 5, 6. It doesn't matter. There is no limitation. Is a patent to be filed a process or product? For example, if you want to protect your invention, process of your invention, you can protect. If you want to protect only product of the invention, you can protect that. If you want to protect both by following your process, if some product results, you can protect that also. So what is that exactly you want to protect in your invention, whether it is a process or product or both, that you mentioned here. If you want to protect a product and process, you mention both. Date of start of the project research. So when did you start your project? This is just for information, date of start. Project or research is funded by, if anybody is funding your project, just mention the details. Prior disclosure. So before you fill this form, did you disclose your invention to anyone or not? Has the work been displayed anywhere? Did you publish it or did you disclose to anyone or not? Has the work been reported or published or presented? Has any related patent been filed by the inventor? If yes, given details. Or if you search your invention in Google Patents or Patent Office databases, if you search and if some relevant patents are there, you try to list here. Basically, why we are asking is, if it is already disclosed and completely disclosed, then there is no way that you can get the protection, because already you disclosed your patent by yourself. There are some exemptions are there, but for that purpose, we are asking all these details. Whenever you are ready with the invention, or if you are partially ready with the invention, you can file this. You can directly come to, this is the free of cost, you can directly come and file the patent. So you need to fill this form. That is what I am explaining. So invention disclosure form of Andhra University, technical details of the invention. So these are the technical details. These are the substantial one. So write a description of your invention, keywords. Based on the keywords, we search in the paid databases or free database, and we will come to know if there any similar invention exists or not. Basically, to search the patentability criteria. Any environmental issues are there, it will harm or it will solve some environmental issues. You can mention that, and use of proprietary materials. So in your invention, are you using any proprietary materials? Something like so is any part of the invention based on the proprietary materials techniques obtained from a third party? So basically, why we are asking this information, because if this is owned by some other, these materials are which we are using your invention, if that is owned by somebody else, so we need to take the license or we need to take the permission. So and sometimes if you provide these proprietary details, it will be useful to search your novelty or inventive step in a proper way based on the materials that you used in your invention. With that also, you can find out the uniqueness of your invention and whether it will satisfy novelty or. And does your invention use any biological material? If yes, please provide it. This is very much important, because, for example, somebody may come up with some invention by using some biological material, some plants, or have you deposited the biological material in an international depository, other thing. This is the idea. If you don't deposit, you just mention no, because this information is needed while filing the application. We need to deposit if we are using any biological information, and if you are using any biological information which is from India, we need to take the permission from Biological Diversity Authority of India. So for that purpose, we are asking this information. You just need to say yes or no, or what is the source of the biological material and what are the materials you use, so that we will take care of remaining things, commercial aspects of the invention. So we are collecting this information. Tomorrow, if the patent is filed and if it passes all the patentability criteria and if it is granted, so you can commercialize this patent. Even before the grant of also, you can commercialize. So for that purpose, we are asking the commercial aspects of the invention. Like before filing, what is the development? Before filing, you are filling this form, right? So development stage, in what stage it is exactly? You know, right? If it is not 100% also, if you have come up with 50, 60 also, still you can file a provisional specification. Within 12 months, you need to come up with a complete specification. So otherwise, your patent will be, your application will be abandoned. So though it is not completed also, you can file your patent application. That's the reason in what kind of stage your invention is. That's the reason we are collecting these details. List of potential license or buyers of the invention. Tomorrow, if it is a if patent is granted, or if you feel there is a potential with respect to some companies, you can mention those details so that we will start commercializing. Commercializing nothing but this invention, who are the buyers, and they can pay your invention. You don't need to produce the product, whatever the invention, whatever the patented product, or you don't need to come up with the end product. Some buyers will be there. Those buyers list, potential buyers. If you can list, it will be useful for commercialization or any technological transfer tomorrow, and with your permission, with Andhra University permission. So IP ownership. So this is a very important one. As per the Andhra University IP policy, university shall be the applicant or owner of the invention. We both have come up with, Dr. Anindya has come up with IP policy. So university shall be the applicant or owner of the invention. In case of a collaborating project or research, the IP right shall be governed by the collaboration agreement. For example, you are a student, by yourself, if you have come up with the invention, or any faculty or any researcher, then he will be the inventor and Andhra University is the applicant or owner. That means tomorrow, if it commercializes, 70% as per the IP policy. 70% of the revenue belongs to inventor, and 30% is belongs to Andhra University. Why 30% Andhra University is taking? Because to file the patent application and what are all the fees and the attorney fees and till the grant of the patent and commercialization, everything, all the expenses are taken care by the Andhra University through Center for Intellectual Property Rights. We are sitting here for that purpose only. We are from Center for Intellectual Property Rights, Andhra University. So because we are spending all the cost upfront, so IP policy is designed that just one second. We are not taking any money. So while filing the prosecution and everything, we are not taking any money. Everything is free of cost, and you can just come up with the invention that will be protected. So we will take care of that. Hiring IP attorney or law firm and converting your invention into the claims and whatever I discussed earlier. Everything will be, we will take care of. You just need to fill this invention disclosure form. So you no need to, we don't charge anything. It's everything is free. Only thing is you have to come up with the idea and it should be implemented. So in case of collaborating project or research, like for example, your invention is funded by some collaboration agency, you need to take the permission from the collaborating project or research, and also what is their IP policy or what is their IP rights, how their IP rights shall be governed. Based on that, the rights will be divided. So name of the collaborating entity you need to mention. And finally, you are declaring that I be hereby declaring that the information provided here is correct and true to the best of my knowledge. If any wrong information is provided, then in case any of the above information is found to be untrue or misleading, we are aware that we may be held liable for that. And also, I or we hereby declare that the invention disclosed above is a result of our own research. If somebody's research, you don't show it as I am the inventor. So, and I or we are the true and first inventors. True and first inventor means you are the inventor, and you are the first inventor, and you are the true inventor. Those names only, whoever is really contributed to the inventor step, those names only you have to include as a inventor. I or we understand that so many people are including, so many other people names also, though they have not contributed. So they should really contribute to the inventive step and corresponding substantial invention. Then only they are treated as inventors, true and first inventors. I or we understand that any obligation regarding the invention is governed by Andhra University's IP policy. So who is the owner of the invention? If you file the patent, so Andhra University. So that is governed by the IP policy. Andhra University is having IP policy. So, and as per that, tomorrow if it commercializes, if you get any royalty, that will be shared accordingly. 70% is for inventors, that is for you, and 30% goes to Andhra University because they are paying all the upfront cost to get your patent done. I or we understand the Andhra University CIPR shall not be liable for any offense. CIPR is our department, Center for Intellectual Property Rights, shall not be liable for any offense action regarding acceptance or rejection of your IP application from Patent Office India. Hope you understand this line. So we will be filing the patent application by hiring a patent attorney, and patent attorney we will represent through law firm. We will represent all the prosecution things, and whatever the prosecution that happens in the patent office in India. We have not modified any columns of the original idea given by Andhra, and don't modify this form. So for that also we are taking the consent, and these are the inventors' name. I said, right, who are all the inventors, true and first inventors, and their signature and date, and supervisor name. You are from some other department, you can get their signature. But inventorship, you will only get it only whoever, whatever the names it has been mentioned here, for them only they will get it. And you need to finally send this form to this address, IPR chair@andhra.university. So these are the contact information, the name, designation, and department, or university, mobile or email of the inventors, and if they belongs to any of these categories. Who is the principal investigator? They can write the who are the principal investigators, who have really come up with the invention. And based on this information, we will be writing the claims. And this is the substantial information you have, especially detailed description of the invention. You have to, in detail, you have to describe the invention by following the rules of the specification, which is mentioned in the patent office. That is enablement and best mode disclosure and sufficiency of disclosure. Sufficiency of the disclosure is nothing but whatever the information you mentioned while filing the patent application, which is there in detailed description. So that information is very crucial. If you don't disclose, if you don't provide that information, tomorrow, if you want to modify that invention, patent office might give some objections. That time, you cannot include any modification which is not there in the detailed description of the invention, which will be filed during the filing of the patent application. So that's the reason sufficiency of disclosure is very important. So you disclose all the details very clearly. It should be very clear and succinct. And enablement requirement is the person who is ordinary skill in that. For example, I am from computer science. I am having ordinary skill in the computer science. So I should be able to understand your invention without any undue experimentation. For example, by reading your invention 1 or 2 times, 1 or 2 trials, I should be able to come up with your invention. I should be able to understand. I should be able to come up with the invention. So in such a way, you need to disclose your invention. If you write an invention where nobody will understand, or if you don't provide complete details of the invention, then that is also one of the objection under the specification, which will give by patent office. So abstract of the invention, existing state of the art, whatever the state of the art before solving your problem, what is the current state of the art, what is the literature, what is the non-patent literature, what is the patent literature, all the information you need to provide here. And in that there is some problem, that's drawbacks you have to mention, and the drawbacks you are solving, that is your invention, that you need to mention in the novelty, and unique benefits of your invention. After solving that, what are the benefits you're gonna get it, and you need to write in detail how to reproduce the invention, because as I said, patent is a quid pro quo. As an inventor, you are disclosing your invention to the public by satisfying specification conditions, something like sufficiency of disclosure, enablement, and best mode. And you are disclosing it to the public. In a return, government is giving a monopoly right, which is a negative right, where you can exclude others from making, using, selling, offer for sale, and importing. All these rights government is giving, because you are disclosing the information in such a clear manner without having undue experimentation. That is the reason government is giving a right. It's a quid pro quo. Inventor gives something and government will give the monopoly negative right, which is exclusive right. That's the reason you need to mention in detail by following enablement. Best mode is nothing but if you can come up with the invention in several ways. At the time of filing, what is the best way, that method you have to disclose. You need to mention that this is the best way to come up with this invention. So this is the invention disclosure form. Just you need to mention this, and you need to submit to the following mail ID. Then we will file the patent. So what patent attorney will we do? And after filing the patent, how you can see what are the databases that I am going to discuss. I just opened the Patent Office database. This is the Indian Patent Office official database in PASE. For example, if you want to find Andhra University Andhra University is the applicant, right? So whoever files in our university, obviously Andhra University will be the applicant. He is the owner. Andhra University is the owner. And whoever come up with the invention, they are the inventors. For example, you wanted to find out how many applications Andhra University filed so far. So you can search the field something like Control F and applicant, see here, and search, see here, you can find the applicant name. So selected search field is applicant name, and please enter the applicant name. For example, here Andhra. And because this website will search based on word by word, so I am using the logical operator. You can see here, select logical operator and or not. Here I want Andhra plus university. That's the reason I am keeping and another field. This also should be applicant name. Here it is applicant country. So I am selecting as a applicant name. So applicant name is Andhra University. So applicant name. So individual words, I am putting the Boolean operator and so that it will search only Andhra University. And can enter the captcha code. Yes. Now we can see. So there are total 60 applications have been filed. So you can see these are all. So this is the first page. You can go to the last page. So these are the patent applications that have been filed by students of this university or faculty or any researcher or any employee for that matter. So, and if you want to see, these are all are published. So I said, right, there are several stages. Once you file the patent, after 18 months, automatically it will be published. These are all published. If you want to know the status of the application, here application status is there. If you tap on this, you can go for the what is the application status. And if you want to see only granted patents in Andhra University, so you can go back and the applicant name is again I'm searching Andhra. So rather than published, so granted. This is just published. Once you grant once the patent is granted, then only it is treated as you got a patent. So after you file the patent application, if it is published, after that it has to go for the prosecution and then it will be granted. So only granted is called as patents. So people think that whenever they file the application and it is published, they are thinking that they got the patents. No. So whenever it is granted, whenever it has to gone through patent prosecution, and if it is successfully passes, patentability criteria, which I discussed earlier, novelty, interest of an industrial application, and it should not fall in non-patentable subject matter, then patent office will grant the patent. then the status of the patent is granted and then published. This is after 18-month publication. This is nothing to do that. Whenever you get the grant of the patent, then only it is valid. So select sexual applicant number. This is the applicant name, right? So Andhra University applicant name. So and operator I am using, and see these two are the, so far there are two granted patents in Andhra University. You can see this one. So this is the e-register, this is the application of that. So I'm opening one. So I'm trying to explain exactly what are the fields and that. So far we discussed it. That we will be discussing. You can see this is the invention type based on your invention disclosure form. So we file the patent application. That is what I said, right? So patent attorney will file the patent application. So he will be writing like invention title. If you disclose properly, then only he will come up with properly. This is the publication number. It is published on this date. This is the publication date. Sorry. This is the publication number, publication type, application number, application filing date. This is actually filed on 17/4/2022 in India. This is the priority number. So here you can see this is initially filed in Australia. This patent is filed in Australia within 12 months from the date of filing in Australia. So this is the first filing in Australia, 19/4/2021. Within 12 months, it is filed in India. So that means it is only filed in India. I guess it is only filed in India. I mean, other than Australia, it is filed in India. So this is the convention application. Because we initially they filed in Australia, we secured the priority date. Based on the priority date, within 12 months, we filed in India. Okay, this is the classification I discussed. There are two kinds of classification. This is the IPC classification. In this classification, this kind of invention belongs. So you can see multifunctional cost-effective smartphone for early flood detection and rescue operation. And also you can see the inventors here. These are all the university employees or students and or any constituent colleges of Andhra. So 1, 2, 3, 4, 5. So 10 inventors are there. So these are true and these are the true. So here the applicant you can see Andhra University and the corresponding letters. See, this is the abstract. Abstract is nothing but rather than going completely into the technical details, it just mentioned the technical features and without going much into the detailed description of the invention, it just mentioned like what are the advantages. So that's the reason while searching. So based on the abstract, you will come to know what exactly the invention. So we search based on the abstract. So many searches, so many database search based on the abstract or based on the title. This is the title. So in that way, quickly they will come to know. And this is the complete specification. So complete specification, I was discussing about claims. Okay, we discussed how to claim independent claims and dependent claims, and how substantial features we are claiming as independent claim and dependent claim. We have seen one example. So these are the claims. These are the legal boundaries. So tomorrow, if some infringement happens, if somebody uses your invention without your consent, so you can sue them in the court. So in any district court, so district court first they will assess. First they will assess this one claims. and they will see whether it is really infringed or not. This is the complete specification. You can see the view application status. So, yeah, cool. So here you can see the application. This is the convention application, Paris Convention. I said initially it is filed in Australia. Within 12 months, it is launched in India. So this is the data filing in India. So priority date is nothing but this one. The first filing date in Australia and applicant name. This is the title of the invention. Field of the invention also mentioned here. These are the, because we are giving it to the law firm, right? So Andhra University has to give the power of attorney to the law firm. So these are the law firm we have given. So this is the priority date. Request for examination. Request for examination within 12 within 48 months from the data filing. Here the data first filing. This is the data first filing priority date. So publication date is within 12 months from the date of priority. So I mean publication date, I mean after 18 months automatically it will be published from the date of priority. So here it is published even before that. That means this is a expedited publication. I mean proactive publication. Proactive publication is nothing but you no need to wait for 18 months. If you are sure that you are ready with the complete specification, and if you are sure that you wanted to get it done fastly, and then you can directly go for the proactive publication. This is the first examination. That means after you request for the examination, so patent office checked your novelty, inventive step, and industrial application, and on 9/11/2022 they have given the report, which contains any objections with respect to novelty, inventive step, industrial application, and non-patentable subject matter, or any specification. So if you can reply within 6 months, or maximum it can be extendable up to 9 months. So within that, if you can reply and patent office is satisfied with your replies, then patent office will grant the patent. So the patent is granted on 5/6/2023. So in between, pre-grant and post-grant is nothing but pre-grant is nothing but during the before grant of the patent, starting from the publication of the patent, application. So anybody can oppose. That is called pre-grant. After the grant of the patent, since 12 months from the after the grant of the patent, anybody can not anybody, any interested person can oppose, which is called the post-grant. So you can see first it is filed, published, and then request for the examination. Under examination also done, and it is disposable. So you can also see the documents. See here so after grant of the patent, it will be like this. So you can see this is the grant of the patent. Data filing is this one in India. So data priority they haven't mentioned. So patent number and see the name. Everybody nowadays, getting a patent is very much important to get a job, or at least filing a patent application. This is the added advantage for me. So if you have a patent, definitely will get a job. I'm pretty sure. So this is the after long struggle, you will get the patent like this. So, for example, intimation of the grants. I just briefly explain it. This is the statement of undertaking, Form 3. Something like, if any information with respect to the foreign filing that you need to mention in Form 3. For example, it is already filed in Australia. So in the patent office, you need to intimate that, while claiming priority also, you need to say that, it is from Australia. So request for early publication. You no need to wait for 18 months. After that, it will be published since from the date of priority. So rather than waiting that, you can request by paying extra fees. So that is for request for early publication. And these are the priority documents. In Australia, it has been first time it has been filed, right? With respect to those documents, these are priority documents. And the power of authority, because this invention belongs to Andhra University, Andhra University is giving a power of authority to law firm or any patent at all, so that he can file and he can prosecute, he can reply to the patent office behalf of Andhra University and inventor and the corresponding inventor. So for that, you need to give a power of authority to that law firm or patent at all. So this is the form, and Form 9 is nothing but this is, as I said, proactive publication. You don't need to wait for 18 months. If you are sure that if you file a complete specification and if you are sure that you are ready with the complete specification. Form for small entity. This is nothing but small entity. So you will get the fees exemption. If you show that Andhra University, because Andhra University is a small entity, this is the educational institution is treated as a small entity. So earlier you have to pay higher fees. If you can show that if it is a small entity, something like MSME or startup, so it is treated as a natural person, and the fees will be very less, government fees. So that's the reason they are filing this one. And Form 1 is about bibliography, about inventor and his details and all, which we are collecting through invention disclosure form, right? That we will be that with that we are forming. We means patent office, IP attorney or patent attorney or law firm. We will file a Form 1, and this is evidence for registration under SSI. The SSI is nothing but a startup. Whether it is a start, if you want to get exemption for filing, you need to show that it is a startup or it is a micro, small, medium enterprise, or it comes under a natural category, so that fees will be less. This is the evidence. So obviously, Andhra University is a educational institution. You can claim for less fees. That is a natural, as a natural person, very less fees will be there. And Andhra University is an education institution. And drawings, with respect to your invention, whatever all the drawings are there, we will prepare, law firm will prepare. Declaration of inventorship. Inventors are declaring that there is a form called Form 5. So where the inventors are declaring that we are the true inventors. I just shown 10 inventors are there. Their signatures we will be taking that they are the true inventors. So complete specification, this is the most important document. So whatever the IDF you are giving, so we will file a Form 2, which is a complete specification. So this is the complete specification, Form 2. So here we are mentioning title based on the invention disclosure form submitted. We come up with the title of the invention, corresponding applicant, preamble to the description. So you can see who is the applicant here. Preamble to the description, and this is the field of the invention. We are asking in the IDF field of the. So here we are asking technical field, right? So based on this one, we will come up with this field of the invention. We will be writing this, and so you need to disclose properly so that it will be easy for patent attorney. Background of the invention. So what is the problem with the current existing art? So what are the problem we are facing with the existing problem? And you need to mention here. Here, this invention is about natural disaster or major adverse event resulting from natural process. If any boat is capsizing, or if due to any natural calamities, if the boats are falling, by using this device, you can protect, you can save the sailors. So this invention is about that, and also you can pass the information to the rescue body. So this invention is about that. So what is the problem you need to discuss about in the background of the invention, and objective of the invention. So what are the, there is problem we have mentioned, right? And what and how the problem will be solved. Those are the objective of the invention. And summary of the invention, you are describing overall summary of your invention. And detailed description of drawing. This is the important one. With this only we are making the claims. I mean, patent attorney is making the claims. So if you are filing, if you want to protect invention, I mean product or process. So if it is a product, you need to describe about what are the elements in the product. So these are the claims for that. If it is a process, you need to describe how the process, what are the key elements in the process that we have to write in the claim language. So that both product and process will be protected. These are the boundaries. So tomorrow, if some infringement happens, whatever you write here, the claim language by a patent attorney, based on this only, it will be decided whether any infringement happens or not by the court. Detailed invention disclosure, you are writing very detailed of each and every step of the invention. Based on this only, we are forming the claims. Claim is the legal language, which will, so these are the claims. Based on the detailed description, we'll be writing the claims. And this is the, and this is the person who patent agent or patent attorney, the person who patents on which date and their signature. And abstract I told, right? So rather than writing a complete details, technical details they are mentioning and corresponding advantage, so that you no need to go through entire detailed description. By just reading abstract, you will come to know what is the exact invention and corresponding invention diagrams and corresponding description, detailed description also I have shown. So Form 18 is for expedited examination, and this is evidence of eligibility rule 24C. It is mentioned here. This is the first examination report I told, right? This Form 26 is power of attorney, and Form 3, as I discussed, Form 3 is for foreign application undertaking. Here it is coming from Australia, so you need to mention about corresponding document. This is the first examination report and corresponding replies. These are the drawings. This is the complete specification, that is Form 2. Just now I discussed about Form 2 and corresponding claims and abstract. Hearing notice. If controller is not satisfied with your replies for first examination report, and you can call for the hearing, you can request for the hearing, and controller will give a chance, and you can explain and get your invention granted. By through hearing, they will give the date. You can directly go and discuss with the examiners and hearing and explain your objections. And if any modifications are there, you patent office will suggest that. So correspondence to notify the controller, that is what correspondence. So written submission. So these are the basic important things which I have discussed. So once it is granted, a patent certificate will be issued. Intimation letter and patent certificate. Hope you understand all the detailed process and corresponding patent database, how to search your patents, how to search specific patents and all. Okay, that's it for the day.